Hello, hello. Welcome to the Bold Inventor Show. I'm JD Hoovner with my co-host, Matt Kolseth.
Hello.
Welcome, Matt. So good to have you. And for those on the podcast, you are missing out. We're in style today. We've got our jackets on, looking quite professional.
Yeah, we're looking real sharp.
We are. So if you're listening, just hop on your Wednesday afternoon, 1:30 Pacific, 4:30 East Coast. Excited for today. We've got the patent legend. Cat's out of the bag. His name is Troy Schmelzer. He's waiting backstage. So he'll be joining us in just a few minutes. So if you're here to watch Troy, don't totally tune out. Okay, hang in with it. We're lawyers, we're attorneys, having some fun here on this live broadcast. Here's your legal notice going across Facebook, LinkedIn, and YouTube. Do not share anything confidential. This is not a legal advising session. We're going to weigh really fun legal information. It's all going to be free of charge. And as Matt always says, it's a money back guarantee. So all the money you're putting in to this broadcast, you can have right back if you're not happy and satisfied. All right. All that out of the way, Matt, what's been going on in your world, man? What's shaking?
Oh man, just busy with work. Kids have been sick all week. My wife is sick.
Oh.
So she's downstairs playing video games in the basement today.
Okay. Well, yeah, good for her. Yeah,
we're doing great, man. We got our first snow yesterday up here in Minnesota, and I don't know. I could complain, but I shouldn't.
Yeah, good. Yeah, we have Hamilton was out sick this week. Kindergartner. He's back at school today. Hopefully, just a one-dayer. So yeah.
Nice.
Yep. I'm coaching basketball. I mentioned that we had our first game last night, and it was awesome. You know, basically 45 minutes of girls 10-year-old basketball. A total between both teams of 18 points scored.
Woo!
So, I mean, I'm talking everybody, both teams.
Everybody, 12, total, right?
Yeah. 12-6.
9 baskets total.
There's a shot. Yeah, it's so fun, though. We figured out the rules, just the basics, which way to go, where to stand, and it was awesome. Really fun. At the firm, we were getting busy, really busy. In fact,
sure seems like it.
Things are picking up. Our phones, I'm getting the warning like, oh, you're going to hit your maximum phone, at the 20th of the month. So really excited to have that opportunity to serve.
Great. Yeah, no, this is usually the time where it feels like it slows down too. And I'm still going pretty strong on the trademark side. So
love it. Well, our agenda for the day, we're going to do our interview first. And I'm hoping we can keep Troy on for the Q&A session.
Cool.
Mainly to bail me out on some of these patent questions I've been kind of choking on lately. I do want to encourage those that are watching live. We've got 3 live viewers out there. Good to see you. If you're new, please click the subscribe button. Like us if you don't hate us. And we're going to take your questions. If you have anything on your mind related to intellectual property, not just patents, trade secrets, copyrights, privacy law. We've even done marital advice. We can do lots of different things on the show. Pop that into the comments box. I'll take your question as priority. Happy to have you on, William. Good to see you. And we'll, like I said, we'll put your question to the top. So let's bring on our guest without further ado, Matt. Mr. Troy Schmelzer. Welcome to the show.
Hi.
Hi, Troy.
Hi.
Hey guys. So good to have you.
Matt, JD.
This will be a pleasure. Yes, good to have you. Well, let's start out with a little background. Who is Troy? Walk us through where you grew up, a little personal background. I'd like to hear where you came from, education, and then your professional career.
Sure. Yeah. So I grew up in Illinois, not too far from Minnesota.
Yep.
Well, we got Wisconsin in between, right?
Right up the road.
Yeah. So I grew up in Illinois. Also went to University of Illinois for education. Got my electrical engineering degree and my law degree there. After law school, I lived in Chicago for about 8 years. I practiced at a little patent boutique in Chicago that's no longer around. And then I headed west. I made a pit stop in Phoenix, worked with the firm called Snell and Wilmer there for a couple of years. And then I completed the trip west and went to California. And in California, I worked with several pretty big law firms. Worked for a while with Hogan Lovells, DLA Piper, Norton Rose Fulbright.
Okay.
All of the big firms. All the big IP firms.
Yeah. I was billing a lot of hours.
I bet. Yeah.
Yeah. Unfortunately.
So Troy, so for those that aren't familiar with big law, maybe some non-lawyers out there, what kind of firms are these? Harken back. What type of clients might you have been helping and work you've been doing?
Yeah. So these are large global law firms. The one, the big law firms that I worked at in California. Generally speaking, they're general practice firms. So they do all kinds of, not just patent law, trademark law, but all kinds of law. And I was always involved in patent prosecution for the most part. Got some trademark experience as well. I still do a little bit of trademark work to this day. Not nearly as much as Matt, I'm sure. I kind of.
Well, you do a lot more patents than I do.
Yeah,
I don't do any patents. So.
But yeah, during my time in these firms, I was generally working for, really pretty much large corporate clients. Towards the end of my time at big firms, I was doing a lot of work for Japanese companies, actually. For about 10 years, I was in Japan for about a month a year. Worked for companies
cool.
it was really cool. It was really cool. But I was doing work for companies like Kyocera, Seiko Epson.
Yeah.
Nice.
Yeah, big companies.
That's really cool. My trademark professor here in Minnesota was bilingual, spoke Japanese, American, but spoke Japanese, and like just raved about Japan and their IP systems, and yeah, very cool.
Yeah. It was really enjoyable, great experience. But after working in big law firms for 15 to 20 years, decided to go out on my own and start my own practice, and that's what I've done. So continuing the same sort of work, but mainly for smaller companies and individuals even.
Yep.
And it's been really rewarding. It's great to work with solo inventors, small companies. Because there's actually a lot more teaching involved. And explaining the patent system and how things work. When you're working for a Kyocera or a Western Digital or a Seiko Epson, they know all of that. There's not so much teaching involved because they already know it. They have in-house IP departments. It's rewarding. You're working on some really great technology, but not so much the teaching element, that I'm now getting and I'm actually really enjoying. In a way, I kind of feel like I've come back to my roots as a patent attorney. I know that sounds strange to say, but it's true.
That's great. Yeah, given all that amazing background, which actually some of that I haven't heard yet. It's awesome, and we get you here, but we're fortunate to get your time to share with our clients at the initial consultation, which is the very first legal meeting that they have and the first interaction. I'd like to talk about that, and what it's like for a client. Maybe you can picture one and kind of describe that meeting. What do you try to cover? What don't you cover? What's involved in that meeting, and so maybe you can answer some of that nervousness that maybe some inventors that might be listening are facing now.
Yeah. So, well, the first thing to say is, we do all we do video conferences. We use Google Meet. And that's very helpful because, a lot of inventors, they like to see who their attorney is. And another great thing about Google Meet is, it enables document sharing, screen sharing. We can go over documents together. So it's been really helpful to do things by video. Especially when you're talking about something complex, it's great to be able to throw up a diagram and talk about it together with the inventor.
Absolutely. Yeah, and I think that's a big point. I think you mentioned it even today before our show. It kind of was the impetus of getting you to come on. By the way, thank you for coming last minute. Is that you get often feedback from people saying, what, this isn't common, even though we're in 2024. It's not common yet that law firms are willing to meet virtually and we're offering video. They expect you to come in or expect you to just handle it on the phone. and we're taking it to the next level here at Bold.
Yeah, and I've gotten some really good feedback from inventors that they really enjoy, meeting in that kind of scenario. Yeah, so in one of these, we call them consultations, initial consultations. Typically the first thing that we will do is, we'll have some introductions, but then I'll ask the inventor to tell me about their invention. And usually they've sent some information about their invention beforehand. So I usually know something about it, but we'll talk about it together. I'll try to get out of them, what are the real key features of the invention here? What problem are you solving? How were things done before? And just try to draw out the real key features of the invention from them. That's usually the first thing that we talk about. Next, usually I'm talking to an individual solo inventor most of the time, sometimes small companies. But I try to gauge their experience level with the patent system. Have you ever seen a patent? Do you know anything about the patent system? So I'll start in by explaining, just a brief introduction to patents, starting with, hey, what's the difference between a utility patent and a design patent? And then based on what they've told me about their invention, I'll try to guide them down one of those paths. Sometimes it'll turn out, a lot of inventor, they're just not familiar with intellectual property. Sometimes it happens that what they're really looking for is a trademark. And, in that case, I'll guide them towards Matt.
Right.
Yep. But so we get into the patent system a little bit, types of patents, utility, design. And then one thing we do, one of the first things we want to do is make sure that their invention is something that's eligible for a patent.
Mm-hmm.
So we will go over that, the different types of eligibility, and give them an indication, is this something that's patent eligible or not? And most things are, but there are a few things out there that aren't patent eligible. So we'll get over that initial hurdle, and then after that, and once we've gone over the patent system a little bit, what we like to do is put up a timeline of the whole patent process, to show the inventor what's going to be involved in the process, starting from this phone call, this video meeting, and, going all the way through to patent issuance. So we talk about that. Inventors are often surprised that, it is a little bit of a lengthy process between patent searching, patent drafting, and then you get into the patent office part of the process. And, that whole process can take several years sometimes. So that's often a little bit of a surprise, but it's
Right.
something that inventors about.
Yeah. Well, hey, I'm going to stop you there just for a second. I think that's awesome. But by the way, thank you for sharing that process. It sounds, exactly kind of what I was thinking. Let's talk about some of the snags that you might have. Did you ever have clients that are really hesitant to divulge their invention? Are they worried about talking with you, even though you're an attorney? And how do you overcome that?
Yeah, that happens quite often, actually. Yeah, naturally, often, an inventor, they've been thinking about this idea for a very long time. And rightfully, they've been keeping it to themselves, which is something that we always advise an inventor to do, is to keep it under wraps as much as possible until they've initiated the patent process. So yeah, they are reluctant to divulge, but everything an inventor talks to us about is protected by attorney-client privilege, and it's kept completely confidential. So we do
I'm sure you
often have to get that.
You have to tell them, hey, even if you don't. Yeah, go ahead.
Yeah, and even then, sometimes they're reluctant to divulge. But that is something we, to talk about the invention, we need to talk about the invention, right? So we're usually able to allay those concerns before we get into the discussion of, the invention.
Yeah, awesome. And the outcome, of the console, let's say, and we're toward the end, what does the client get? What is the result of that meeting?
Yeah, so the result is, we're trying to provide some guidance. So usually we're going to, sometimes the invention may just not be at a stage, it may not be ready to even start a patenting process. And in that case, I'll say, look, you need to do a little more work and give them some guidance on getting a proper disclosure together. And, on that point, any inventors listening, it is really important to, for good record keeping, to really write your ideas down, sketches, keep track of all of that information, because the more information you can give me, the better I'm going to be able to understand your invention, and the better guidance I'm going to be able to give you.
Right. Yes,
So,
I love that.
yeah, that's very, very important. If I was to say, one thing to an inventor, it's, write everything down, keep track of everything, get it out of your head and put it on paper.
Yep. We got one question coming here from William. He's got, let's see, do you have a recommended online resource for NDAs, non-disclosure agreements, when reaching out to have someone do the drawing for the patent? I have a ton of questions and don't want to derail the stream. William, don't worry. Feel free to derail, by the way. So Troy, I'll let you answer this one if you'd like.
Yeah, well, NDAs, they are, and an NDA is a contract. So, NDAs are useful. One thing I tell people, when you get into the patent process, ultimately, hopefully you're going to get some patent protection at the end of the day. But in the meantime, you really don't have any protection until your patent issues. So an NDA, that gives you a layer of contractual protection on top of the patent protection. NDAs are, as being contracts, they are governed by state law. So, you want to find an NDA or consult an attorney in your own state, where that NDA is going to be executed. As far as online resources, I don't know. Do you guys have any suggestions on that?
Well, I would say feel free to shoot me an email. I have a really robust network of business law firms and business attorneys. Like Troy was saying, we can make an introduction to you. I would not recommend grabbing an NDA online as published. If you want it to really be something you can use to rely on, to be enforceable in your jurisdiction, you want to spend that, a few hundred, maybe even $1,000 or so or more, getting that contract buttoned up. And so feel free to reach out to us at Bold. Even if we're not handling your patent work, we can make an introduction to a business counsel that'll make that contract work for you.
Yeah, I like that, JD. I would also say too that, if you are reaching out to one of these legitimate patent drawing companies, we have one that we use at the firm pretty frequently, but if you're reaching out to them, they might have something in their terms of service that covers you. Also, they might have their own non-disclosure agreement that you can request them to sign or send to you to review, and that way you might save yourself a little bit of money. I would look at that too.
Perfect. Awesome. Well, thank you, William. Yeah, don't be shy. Send out over your questions. We'll try to prioritize them as you have them. Well, Troy, just kind of buttoning up the consultation interview. This is kind of the heart of what we wanted to have you share today. Anything else you wanted to mention? Maybe shed some light on what a legal consultation, that first meeting is like. What you'd like people to know about anything?
Yeah. So it will usually the outcome will be a recommendation. If an inventor comes in with an invention and a good disclosure, usually my recommendation is going to be to start with a patentability search and opinion. And what that is we go out and do a search of the prior art, issued patents, published patent applications, non-patent literature. And basically what we're looking for is, is this idea new? Is your idea new? Has it been done before? And we want to find that up front because, for one thing, if we do find that the idea is already out there, which, we hope it's not, but sometimes it is, you can save a lot of time and money by, if you're not going to get a patent, that patentability search and opinion is a very valuable investment because it prevents you from spending, continuing down the process when you're ultimately not going to get a positive result, most likely. That's not how we want the outcome to be, but sometimes it is. Now, if we do the patentability search and opinion and we don't find your idea, then the next step of the process would be a patent application. And you have a choice. You can start with a provisional patent application. You can go with a non-provisional application. Oftentimes, inventors like to start with the provisional application because the requirements are a little less strict. They can generally be prepared faster and be filed faster, which is often very important for an inventor. They want to establish a filing date as early as possible. A filing date is presumptively your invention date. So once you get a filing date, you kind of put your flag in the ground, and anyone that comes after you is trying to file a patent application on the same idea, you're going to have priority rights over them.
Love it. Hey, Troy, so one point I want to make there, or a question I actually should ask. Sometimes I've heard people ask me, hey, this technology is moving so fast. I want to skip the search and just file it right away. Does that ever make sense? Or are they taking too big of a risk?
Well, look, I would say there are times, if you're in my former career, working for very large companies who have teams of engineers, they have a very good idea of what the prior art is. So maybe for a very large company with those kind of resources, it may make sense for them. For an individual inventor or a very small company who doesn't have those kind of resources, it's very difficult to know what's out there in the prior art. So, usually, in my opinion, it's the best move to have the patentability search done first. Not only for you to know what's out there, but it also allows us to write a better patent application for you. When we know what the prior art is, we know ultimately what we're going to have to distinguish over in order to get a patent allowed. And that helps us to write a better patent application when we already know what's out there that we're going to have to deal with when it gets into the patent office.
Love it. Troy, thank you so much for sharing that with us and for being up for this interview. Matt, did you have any questions for Troy before we take our
No, it's great to see you again, Troy.
Yeah, good to see you, Matt.
And if we can, are you able to stay on with us for another 15 or so minutes, Troy?
Yeah, sure.
Wait, okay, let's go into our Q&A session here. And just before I do that, I want to just put this link one more time to schedule time for a free discovery call. You'll speak with Dallas or Reno. If you've got an invention, you want to talk with Troy, you got to get through Reno and Dallas first and discover who we are, what we're all about. And they'll set you up with Troy, get you on his calendars. Troy, you're getting some love there from Jonathan Mitchell. He says, thanks for being on.
Thanks, Jonathan.
Same with William. William did have a question. Let's start with him. He's got some stuff here he wants us to look at. He's a veteran, okay, and reached out through veteran resources. It may have been when he was asking about for online resources, and he got connected to the Kellogg School in Chicago. He was kind of in the same geographic area as you went to school, and they seemed reluctant to help. And so that was more than a year ago. So he's maybe worried about the NDA. There was no NDA signed. And the patent search found there's a few other similar products out there. So he's frustrated with their response. Any issues there? Maybe statutory bar concern or anything to bring up on his work with the school?
I guess I'm not quite certain what kind of work was being done for the school here.
I know. If I was and William, feel free to plug in some more information here if you want to. If you want to maintain confidentiality, obviously, I encourage you to schedule that meeting, discovery call, and we can help you out with your specific situation. In general, I'll say if you're working with a university and a professor, let's say, usually they're pretty good about having a contract in place, with a technology transfer office. If it takes the next step where they're going to be working with you and putting resources into researching. If it was more of an informal discussion and it was just shared, with one other person, I think technically it's not that could perhaps rise to a public disclosure. in essence, the law that I'm talking about here is the statutory bar. And so if the invention's been publicly disclosed or offered for sale more than a year ago, it's not really eligible, and it will be invalidated if it were to be filed. So in this case, I don't know if that's the issue here. Maybe there was enough of either a formal contract or enough of a handshake.
De facto attorney-client privilege, right?
Right. Yeah. That's the issue I'd want to address first. Troy, what do you think on that?
I'm sorry. Could you repeat that?
Well, okay. If William spoke with the university about his invention, told them all about it, wanted to get their help with it, does that start the clock, the statutory bar clock?
Boy, it's I would call that a little bit of a gray area, probably.
We love gray areas, attorneys.
Yeah, safest to have an NDA in place. I think the standard is it reasonably available to the public, right?
Yeah.
Have you made a public disclosure? Talking to a professor at a school, I don't think that conversation in itself would be a public disclosure. However,
love that answer. Love that. Let's stop right there. That's perfect.
I'm gonna go ahead and say Troy's right.
I'm going to second that. And so William says he's not a gray area kind of guy. He said no public disclosure. So, but I think maybe another part of that question he was asking is, hey, they didn't help me much. And I think that goes in line with a lot of free advice. It's worth what it costs, what you're investing in, right? And when you're getting free advice, pro se advice, I've heard this a lot where, they'll say they're helping you out, but really, are they going to give you the full effort? Are they really going to put their best foot forward and truly give you the same level of service they would if you were paying them? I'd say usually not. Sometimes we'll have some standout, amazingly altruistic folks, but it's in large part going to be you get what you pay for. And so that's what my quick answer is to that, William. If you're able to get enough funds together, I know there's a ton of resources out there for veterans, small business loans, VA office for loans, credit, investing in at least a consult. And then if you can, a patentability search, I think would be well worth your while if you think you're onto something big. All right, Matt, I'm going to put you on the hot spot. We've got 2 trademark questions coming in from Avo.
Let's do it.
I'm going to let you pick. We're going to Potomac, Maryland, or San Antonio, Texas. Where are we headed?
We're going to Potomac.
Going to Potomac, East Coast. Feels quite colonial.
Yep.
All right. I'll plug this one in. Matt has not been warned at all on this question. Here we go. I've got a question about trademark record and its first use in commerce. I'm the manufacturer. I produce some goods and have registered mark in my country. I'm guessing not the US. So the question is, if someone will start selling products, not their products with my logo, but my products on the territory in the US, who will have the priority over my trademark? This person who began selling it commercially by selling my products for me, because it's my product and all the info about the label is about more and more. Okay, did you get enough on that?
Yeah. So
Okay.
This seems like this individual, to frame it up right, let's just say they're in the UK, they have a product, they have a trademark in the UK, and someone's buying them and selling them in the United States and kind of claiming to be them, right? Who's got priority of use in the United States? Well, technically, like this third party is the one using the trademark in the United States, but they don't have any trademark rights because they don't actually own the trademark or the brand, right? If they were to, go to the USPTO and say, we're this company and this is our brand, well, they're committing fraud on the USPTO by doing so because those products are not their products, right? They're a third-party reseller of those products.
Ooh, that's cool. Interesting. Okay.
Yeah,
So the person selling, if they're putting their brand on,
if they're putting their own brand on this third party's products and selling in the United States, that's fine. Right?
Okay.
But for my money, I would say that taking someone else's products from a third party country and then claiming to be that company here in the United States, that's fraud on the USPTO if they move forward with an application. That's how I would, pursue litigation against this company. Would be, we'd file our own trademark application in the United States on behalf of like the UK company, right? And then if we had to, we'd pursue litigation against the third party in the United States claiming to be the company that sells those products. That's how I go about it. It's a little complicated, right? Because at the end of the day, you get rights based on use in commerce here in the United States. So if you're selling products in the United States, if you're offering products or services for sale in the United States, technically you have first use of that product or name. But if you're holding yourself out to be a third party or a company that you're not, that's fraudulent behavior. And the USPTO doesn't look kindly on that.
Perfect. Thank you, Matt. Well said. All right, let's take a patent question here. This is coming from our Quora group. And Troy, since we got you, I'll let you tee this one up first.
Okay.
Can you explain the difference between a patent pending and a patent issued?
Okay. Yeah. So a patent pending is, you can say patent pending when you have a patent application on file, when you filed a patent application with the USPTO. So that can be either a provisional or a non-provisional. Once you have that on file, you can say patent pending. A patent issued is only at the very end of the process when you filed your patent, the patent office has examined it, and then they've actually issued you a patent. That's when you can say, that's when you have an issued patent. Yeah.
Perfect.
And kind of similar to trademarks, right? The difference between the encircled R and the TM symbol. Yeah.
Yep, that's exactly right. We tell clients when they get that application serial number, even before we even apply for the trademark, they can use that TM symbol, but they can only use that circle R symbol when they receive an actual registration number from the USPTO, which typically is about 14 months after the application.
Can take a bit.
Yeah.
Right.
Yeah, it's crazy how long it's been taking these patents and trademarks to get through. Despite the USPTO hiring 800 patent examiners this last year, something like that. Yeah. And like another 100.
Yeah,
800.
I've heard they have over 8,000 examiners now.
That's a lot.
Yeah. So on the patent side of things, it'll typically take you several years to go from patent pending to patent issued. Sometimes longer. If you're in a hot technology area like AI, it's probably going to be even longer than 2 years.
I will say, though, we have had some success with fast track, track one, and first time filer applications getting to the front of the line.
Cool.
Seen patents get filed and issued in the same year. Not saying that's going to happen for everybody, but there are ways to expedite and get it done fast. But by and large, you're right on, Troy. That's exactly what I've experienced too.
I wish we had that fast track at the on the trademark side.
They should. All they gotta say, inventors pay us a couple extra grand, and we'll put you to the front. That's a great moneymaker. I'll pass that along to.
Yeah. They should do something like that. The closest thing we had to that was like during COVID. If you had like a COVID related product or service, right, and you could, try to get to the front of the line, for exigent circumstances, essentially.
So there's ways to make the petition, make it special on the patent side if you're related to certain, energy, production, I believe, or other areas where it's related to national security. Well, anyway, ways to enhance, or what was it? Not national security, but anyway. Okay, I'll give you a softball, Troy. Here's a little bit. I'm turning the notch up on difficulty a little bit.
Okay.
Same group out of Quora. How can I be sure I'm infringing a patent?
This is great.
Well, that's a great question.
Hire Troy. Talk with an attorney.
Even judges aren't sure sometimes, right? But yeah, so to know if you're infringing a patent, or to at least assess whether you're infringing a patent, you want to look at the very end of the patent. And that's where you'll find some numbered paragraphs. We call those claims. And what you need to do to determine whether you're infringing a patent is you need to go through those claims element by element, and you need to compare the claim to your product. And your product has to match up with every element of the claim. Has to be a one-to-one correspondence as you go through the claim. So if your product is missing an element that's called for by the claims, so say the claim, just very simple example, a pen comprising a tip and an eraser, and all you have is the eraser. You don't have a tip. That means you're not infringing that claim. Now, one common misperception is sometimes people will think if you add something to your product that's not in the claim that you can avoid the claim. That's actually not true. So if the claim calls for A, B, C, and D, and your product has A, B, C, and D, but it also has E, you're still infringing that claim. So when you wouldn't infringe the claim would be if the patent calls for A, B, C, D, and all you have is A, B, and C, but you're lacking D. So that's how you would know. But I would encourage you to to seek out counsel on that, because it can be a pretty involved exercise sometimes to make those determinations.
Absolutely. Thank you, Troy. That was a great explanation. I like that. Pencil with the tip and eraser, real simple analogy. And that's what this acronym here.
That's what was on my desk.
There you go. That was smooth. Freedom to operate. So we don't do a whole lot of them, but from time to time we help sophisticated individuals or businesses make decisions about, am I free to sell this product without risk of being sued meritoriously? And they ask that question, am I infringing anyone's patent? And they go through that much more in a rigorous way, but am I reading on each of these elements of the claim? So it's a good question with can be a very complicated answer.
Yeah, and sometimes I was going to say, sometimes when it's a really close call, maybe there's one element of the claim that it's just a close call. Sometimes one thing that we have to do as attorneys is actually go into the prosecution history of the patent and look at how did they get these claims. And sometimes, if arguments have been made one way or the other about a certain claim element, then the patentee is stuck with that. So if the patentee is argued, hey, I should get a patent because my claim distinguishes over the prior art for this reason, they're kind of stuck with that claim interpretation. So sometimes when it's a close call, you have to dig even deeper and go into the prosecution history.
That's cool. That's really fun patent nerdy stuff, right? Where it's like, even during the process of getting the patent, you might have, kicked yourself in the shins by the way you argued to get the patent rights. Okay. All right, Matt, we're heading back over. We're going to Texas here for your second trademark question.
Let's do this.
We're talking about apparel for 400. Just kidding. No, for a trademark logo. Oops. Oh my goodness. This is the same one. Here we go. This is the same one? Nope. I'm confused about how many category codes I need to pay for. I want to trademark a logo to be on artwork, to use a print on-demand service for placing art onto products, like mug, t-shirt, tote bags, kind of swag. They sell artists for paying commission. I'm not associated with manufacturing process of a product and not using a logo as a brand identifier like Nike. They go on to say, they're not using a logo like Nike. I not expected more than just a trademark for the logo under code 16 for art applications to be associated with me. Thoughts on that, Matt?
Yeah, I got it. So they're getting a little lost in the trees here. Okay. So when you think about like what your business does, right? You can be a product business or a service business, or maybe even both. This individual is a service company, right? They're taking people's desires for branding products, and they're placing their product logo on the product, right? They're not actually selling mugs, t-shirts, posters, anything like that. They're a service company. Yeah. And so, if you're branding products for other people, you could conceivably be, if you looked at it just at face value, it could be like in 8, 9, 10 different classes of products at the USPTO. But that's not the trademark that they're offering their customers. The trademark or the service that they're offering their customers is basically printing services on behalf of third parties, right? So it's a single service that they're offering, right? They're not selling mugs or t-shirts or whatever. They're just offering this service of basically printing products for customers, maybe drop shipping them. In which case it's pretty simple. It's just a single class 35 application. Class 35 is business category at the USPTO. It does anything from online retail store sales to retail store sales to business services. I would assume that most of what they're doing is going to be in class 35. So
that's awesome. That's a great answer, Matt. It doesn't matter what product they slap their client's product on.
Yeah, because at the end of the day, consumers aren't buying the mug from them. They're buying the service that basically brands, or prints the product for them, right? So that's what they're offering their clients. They're not offering their clients t-shirts.
Yeah,
that makes sense. So, and way that I think about that too is, where does the client make their money, right? When their client pays them the money, they're not buying the mug really, right? They're buying the service that puts the art on the mug. So it's probably just a single class application at the USPTO.
Cool. Awesome answer. Thank you, Matt. Okay, let's see if we have maybe one or two more. We've done a handful already. I saw William had a final question. Let's do William's, and then we'll go to our Shark Tank Bold Bite. So we were talking a bit about how long things can take or how short they can take through the patent office. And William asked, what types of products and ideas are processed faster? So is there such a thing of that, Troy? Have you noticed that certain technologies?
Yeah, for sure. And, it often corresponds with, what's hot in the news that you see. For instance, right now, AI, artificial intelligence, which it kind of took over for blockchain. That used to be the hot technology. So in the patent office, patent applications get assigned to examiners, based on the examiner's area of technology. So when you've got tons of applications being filed on AI-related applications, for instance, the number of examiners in that area doesn't necessarily increase. So you've got the same number of examiners that have a ton of applications to examine. So in very hot technologies, the applications tend to get processed slower, just because the examiners are overwhelmed and they have very large queues of applications. And unless you do something like a request for accelerated examination or some kind of petition to make special, then your application is just going to get examined in the order that it was received. So you go to the bottom of the pile or the top of the pile.
Right.
Yeah, but on the other hand, if you're filing an application in a relatively, an area of technology that just doesn't see so much inventive activity going on, then your application is going to get examined a lot faster.
Perfect.
Hey, Troy,
if you file.
Question for you, Troy. This kind of relates to what we see on the trademark side. So on the trademark side, if I have a client who's got some pending trademark applications at the USPTO, and say they've been around for 6-7 months pending at the USPTO waiting examination, and we submit a third application, a lot of times that third application is going to get reviewed with the first two. If it's in the same field, I assume that's going to get assigned to the same examiner, and he or she might decide to just do all three at the same time. Do you ever see that on the patent side?
I don't see that so often. No.
Okay.
Now I've seen that in the trademark side also. But no, I have not seen that in the patent side. What will happen though, if you have a pending application and you file a continuation application of that, a continuation application is basically a new application, for anyone who doesn't know, where it's basically the same application that you refile, but you're seeking different types of claim coverage. So you'll have initial application, you'll get one kind of claim set, and then you'll decide, my claims aren't really broad enough, or I want to cover a different aspect of my invention. So then you file what's called a continuation application, which is you have the same description, but you're changing your claims, and you get to go all the way back to your initial priority date. So for those kind of applications, often they will get assigned to the same examiner, and you will see examination happen more quickly. I'm not sure why. I can only assume because the examiner is already familiar with the application and it's something they can get off their plate pretty quickly because they have that familiarity. I don't know if there's a formal process in the patent office where, that I don't know exactly how that happens. I've actually tried to find out because we've had situations where we actually want to get the application assigned to a different examiner. Because,
yeah, there's a couple trademark examiners at the USPTO. When I see their name come up on an office action, I just knock my head against the floor,
Well, William wants to thank you, Troy, for that. He's encouraged and he's going to get off of his butt and go take action. So thanks for participating here today, William. Okay, we're going to go to our last segment here, our Bold Bite. I've got a fun one. We're probably going to miss next week because of Thanksgiving holidays, so why not dig into a Thanksgiving topic today? So I've got a really fun. I just laughed out loud when I saw it. I'm not going to tell you what it is. It's related to Thanksgiving. So I'm going to share my screen, and we'll go from there. And so, Troy, would you go on mute while we're doing our audio?
Sure.
Thank you, sir. All right, let's find it. Here we go.
More exciting.
Hi, Sharks. My name's Lance Burney.
And I'm Kim Burney.
We're from Sanford, Florida, seeking $100,000 for a 20% equity stake in our company.
And we've created a fun new twist on a family tradition. We love entertaining our family and friends, especially during the holidays.
This year, instead of cutting the turkey with the same old boring knife, why not wow your family and friends with the Mighty Carver?
Oh, gosh. The Mighty Carver is an electric carving knife that looks, sounds, and feels like a chainsaw. Your family and friends will love it, guaranteed to put a smile on their face.
Not only is it fun, but it cuts really well.
Great.
Easy. Wow. And it's just not for turkey. It has other uses as well. You can use it on pineapples. You can use it on cantaloupes and bread. My personal favorite is the morning bagel.
So this year, be the life of the party. Create fun family memories with the Mighty Carver.
Mark, would you like to come up and give it a try?
Sure, why not?
Whoa, what a man, what a man.
Man and his chainsaw.
Where are you selling these primarily?
So we went to the International Houseware Show last March, and we picked up some big resellers right off the bat. Sharper Image, Grommet, Ace Hardware.
In the stores, the physical retail.
We just got our purchase orders while we were here for that.
So guys, this is very easy to demonstrate visually, and you can sell direct to customer full margin.
Yes.
Yes,
Why
that's what our
aren't you doing
plan
more of
is.
that?
That's what our plan is.
Our goal is to get, we got kind of skewed toward the resellers right now. Like 90% of our business is with resellers. I need to get that back to buying direct to the consumer off of our website. Because right now we're splitting the money with everybody, and I'd rather bring it back our way.
All right. Break down the numbers for me.
So we've sold 8,500 units
And in how many months was that?
the past 12 months.
12 months. What was the total sales figure?
163,000 last year. We've sold 41,000 year to date.
So what does it cost you to manufacture and what do you sell it for?
All right, so it's $20 landed here in the US. We sell them for $69 to $89 retail.
What does a typical electric knife sell for?
Just a regular plain electric knife.
Yeah.
I mean, if a chef puts their name on it, it could be $169, but you can get the cheapest one at the box store for maybe $19, $20.
Do you have a patent or any type of coverage on it?
Yes, we have a design patent and a Chinese patent.
And it's pretty broad. Anybody that tries to make anything that looks like a chainsaw on an electric knife.
That's all you need. Yeah, that's all you need.
Okay, very demonstrable. I'm making the assumption with the right digital buy. Guys, I'm interested in this because it kind of fits into my Chef Wonderful world. And I could actually get behind it, shoot some videos. I've got 3 studios I shoot commercials in. I'll do the deal, $100,000 for 33 1/3%. 3 amigos. I want to be a third partner.
Wait a minute. I use an electric knife often for fishing and then I use another one inside the house. Yeah, I like it. I think you guys are fun. I use electric knives all the time. So I'll give you 100,000 for 27.5%.
Wow.
Unfortunately, you're not Chef Wonderful.
Very lucky about that. Thank you.
Thank you. Barbara, did we answer all your questions?
I'm just trying to think of how I could outwit. Wait.
Don't be so fast. Relax.
You know what happens after we keep dancing
It could
around?
go.
We've crammed course 11 seasons. So
Yeah. 25% right now, $100,000.
How about 22?
25. I'm offering you 25% for 100,000. That's 5 points over what you asked for.
And he's really into it. I don't care about it. I just want to take the deal.
Yeah.
Yes or no?
A sharp thing.
Guys, do you want to make an offer? You're about to lose the deal.
You know what? Hold it. No,
This
we're
is
not
really
going to lose the
scary.
deal. Look at over here.
All right, he does the deal with Damon. I don't want to go too long. He
Nice.
did get the deal. Yeah, so yeah, 25% for 100 grand. So what's your initial take on that, Matt? Was something you would pull out, or is it too novelty goofy?
Yeah, it's fun, right? I mean, it's a holiday kind of gift, right? Party Trick comes out of the closet once a year. They do have a trademark registration for Mighty Carver in the for electric knives, Class 7 at the USPTO, and it is registered. So yeah, great, love it. So they ended up disclaiming the word carver because it's descriptive of what the product is. It's a electric carver, essentially, right? So at the end of the day, they're registered for Mighty Carver without the disclaimer, with the disclaimer to Carver, but also with the logo. So they look good from my perspective. I always say it. I'll say it again. I would really like to see a second application for the online retail store services that would prevent other people from doing anything similar to Mighty Carver from a retail perspective. So that would be the next application that I want to see from them. Troy?
Yep. Oh, I got you on mute still. There we go.
Yeah, I thought I heard them mention that was covered by a patent application also?
Yes, I did. I found it.
Yeah.
It took me a little while to find it, but
Is it just a design patent?
design patent?
That's what I was wondering.
Yeah.
That's what I was wondering, if it was a design, because I don't know what the utility, the new utility.
Yeah, I don't know what the utility it would be either.
Yeah. So it's a cover for an electric knife. So they kept it pretty broad. Chainsaw cover for an electric knife. And
That's smart.
That's the entirety of the claim there. The ornamental design for a chainsaw cover for an electric knife. And so maybe take a quick moment, Troy, walk us through what we're looking at in patent drawings, specifically for design drawing.
Sure. Yeah. So a design patent does just cover the appearance of something. So, what you're seeing there, the coverage that's provided by a design patent is defined by the drawings themselves. So you're not getting protection on the way that knife works or what it does. You're only getting protection on the way that it looks. And so your protection is going to be a knife that looks pretty much exactly like that. For design patents, you don't have to change it too much to avoid infringement of it.
Right. And that's probably up for a little bit more interpretation. It's not as clear, perhaps. There's no words to kind of get muddied about.
Yeah.
Let's say they take a handle off. Would that be, in your mind, enough to avoid infringement? Put you on the spot with that. So no handle on the top.
I can't really tell. So sometimes in a design patent, part of it will be in dashed lines, and those drawings aren't clear enough for me to see. So parts of the design that are in dashed lines are not part of the protection, but it doesn't look like that. The handle's in a dashed line. Yeah, I would say that if you took the handle off, that definitely puts you in the neighborhood of not infringing that patent.
Right. And so while a design patent is good, I think that, hey, I'll definitely support you there. I think it can be quite limited in terms of the scope of rights you get for a design patent. So I hope that they had initially sought a utility application. Maybe you correct me if I'm wrong, it's a pretty low bar for utility. If you could show entertainment or some, even a protection-based cover argument. Is that stretching too far? Maybe they looked and saw there was enough prior art that it wasn't worth going for that on a utility side. We're, just making hype.
Yeah, that. Well, when they mentioned that they had patent protection for that, my first thought did go to, I wonder if that's a design patent, because it looked like it was working just like an electric knife you would see, and that it just kind of had a cover over it. For utility patents, if you're adding something just kind of ornamental, which it appears that to be the case on that, it can be a little difficult sometimes. That may be why they opted for a design patent.
Right. Yep. Well, quick little update here, the Shark Tank update. So they had a rerun on. They did get the investment. They did a press release where they closed the deal with Damon. Damon John's team worked closely with Bernie's marketing team and lined up some vendor contracts. So they did get that done. Unfortunately, though, a month after airing, they placed a large manufacturing order and they lost their money. So Damon supported them through the time. In October 2023, they're in negotiations with Lowe's for retail distribution. So Damon John really stuck with them, and they're actually a pretty good success story. They've got their own website up, selling on their own website and on Amazon. So a success story. They're kind of dogged and pursued it. So they're selling the product.
Yeah, so it sounds like they sent some money overseas and never saw anything up from it.
Nothing. Yeah. We got a comment here from Fano Sumi. Thanks for joining. Quick question here. Hello, I have an invention of a website similar to Wikipedia, but its content is very different, and I have a simple design for it without a design difference. My design is with the written explanation in my notebook. I need to sell it because it's unique. What are some of your thoughts here? Someone's got basically a competitor, Wikipedia. My mind goes to potentially graphical user interface protection through design patents, maybe. If you've got a unique interface and it's going to be constant, thinking about, that type of service. But in terms of functionality, I'm not so sure. Obviously, we'd have to discuss that in a confidential legal consultation. Maybe there's a way you're collecting data, analyzing it, sorting it, leveraging AI, lots of different ways you could be managing, analyzing, and presenting the data. If it's a unique way, then it could be protected there. All right. Matt, any final closing thoughts?
Go Vikings.
Go Vikings. Oh, okay. Go Seahawks.
Go Seahawks. Yeah, no, I'm good.
Yeah, go. Have a happy Thanksgiving, you two.
Likewise, fellas. It was great seeing you.
Yeah. Thank you again, Troy, for being on. As always, Matt, thanks for being with me here.
It's been great.
Problem Spirit Bold Patents. Wish you guys a great day and good holiday. Go big, go bold.